How is the bail amount determined in Oklahoma? I'm Tulsa Attorney James Worth. That's the question that we have. So if somebody is being prosecuted in state court, a bail amount almost always is going to be set to allow them to bail out because they're presumed innocent until proven guilty. And the purpose of bail primarily is to ensure that people appear for court. So how is that amount determined? Well, in some counties, particularly the larger counties like Tulsa County, Oklahoma County, they have bond schedules, so it's super easy. They have this published report that lists all the potential charges and everything. And it's 28 pages long, and it's real small print. They've got all the different crimes on there, and it lists the amount for each one. So if the crime that you are charged with is on this list, then they automatically set the bond at that amount. Now, that is a good thing for the defendant in the case because it's set super quick, which means that the faster it's set, the faster you get a bail bondsman to bond out, or the faster that a family or friend can come up with that money and get you out. So that's the benefit, is that it's super quick. The detriment is that it's not specifically determined based on your circumstances, and you may want to request a motion to reduce that later, which you can do. But the fact that it's set by the schedule means that it's fast. But not everything's on the schedule. We've got some examples for you. So simple assault and battery, it's a misdemeanor. $500 bond, automatic in Tulsa County. There's Tulsa County bond schedules. Okay, well, what if that assault and battery is on a DHS employee? Well, then it goes from being a misdemeanor to a felony. It goes from $500 to $5,000. Okay, but what if you're being charged with A and B on a DHS employee, but you have a former conviction of a felony? Well, then it doubles again, and it goes from for this one, yeah, it doubles again, goes from 5,000 to 10,000. Okay, well, what if the assault and battery is on a minor? Well, that's a felony, and it's 10,000 as well. What if you have a prior conviction of felony then? Well, it doubles again, it goes up to 20,000. All of these things are on the bond schedule. Okay, so that one was a felony, the rest of them were, one was a misdemeanor, the rest of them were felonies. Well, what if instead of being simple assault and battery, it's domestic assault and battery? All right, well, that is also a misdemeanor, but because it's domestic, there's no amount set. So in this bond schedule, it's going to show a 0, but 0 doesn't mean you don't have to pay anything, you just get out. 0 means no bond is determined automatically by the schedule, and the judge has to make that determination individually to your case. So the way that it's set up in Tulsa County, all domestic offenses require a specific determination. So even though it's just a misdemeanor, and all of these huge, horrible felonies have amounts set, misdemeanor for domestic, it's not going to have an amount set. It's going to be specifically set by the judge. So that's how they're initially set, is generally by schedule or by an individual determination by the judge if it's not on the schedule. But once you've got notice of that, if you can't afford to bond out, you do have the opportunity to request a motion for a bond reduction or a motion to determine bond. And at that point, it goes before the court for a hearing specific to you, where the court's going to go over, or whereas you're going to argue based on the Humphrey standards, as in the Brill case. So if you've got any questions about bond in Oklahoma, you want to read the Brill case. A lot of good info in there. It's 1998. OKCR49. But in that Brill case, it actually looks to the Humphreys case. It comes from 1979 for the 8 factors, to determine what the bond amount should be. So if you want to know about that, I've got other videos out there that goes through those factors. But for general information on how bond is determined, or bail, I should say, is determined, then that's the information I have for you. But if you're dealing with this circumstance, you're going to want to talk to an attorney privately, confidentially, to receive actionable legal advice. To get that scheduled with a lawyer at my office, you can go online to makelawEasy.com.